Welcome back to another J. Harris Roll Call. I'm Joey Sperlazza, an instructor at the J. Harris Academy of Police Training. Today we're going to discuss two New Jersey cases that recently were decided at the Appellate Division. They're both unpublished decisions. However, it's important to look at these so we can understand where the court is going and make sure that we have a good understanding about the underlying cases. First one I want to discuss is State versus Cook. Officers were dispatched via 911 to a group of people that were standing on the corner. The caller alleged that one of them had a gun. He did not give a very particular description of the actors. All he said was that there was a group of teens and two of them were wearing all black. However, what was relayed by dispatch was that it was a black teen wearing all black. It was an error on the dispatcher's part. The officers responded, and when they got there, they saw a group of 4 to 5 individuals, generally matching the non-particularized description. One of them, the shorter of the two, got behind the taller male. He bladed his body away from the officer as he approached. The officer immediately went up to that subject and patted him down, discovered a handgun on his person. So the question posed to the court was this approach valid? And they said no. The approach and immediate seizure was improper because they did not have a particularized description of the individuals, and because it was not particularized, it was not enough to automatically do a frisk. He also said in the appellate decision about the furtive movements, they said that at best it was an ambiguous indicator of activity. He stated that blading was turning sideways to block the officer's view while moving behind the taller man, and the officer actually showed and demonstrated to the court what the defendant's movements were. So seemingly furtive movements without more do not support reasonable articulable suspicion of criminal activity. The description of blading did not give rise to reasonable articulable suspicion that he was armed. Instead, it was just an ambiguous indicator. The officers didn't approach here and make an initial field inquiry. If they did, it would have been viewed a little bit differently. The court viewed that as soon as they approached, it was an immediate seizure. There's two cases that we discuss in our Road Cop Essentials and our 2-day breakdown class. Florida versus JL is a U.S. Supreme Court decision. In that case, an anonymous tip alone is not enough to give us reasonable articulable suspicion to make a seizure and pat down for weapons. In that case, it was a black teen wearing a plaid shirt at a bus stop. The caller stated that he had a gun. It was an anonymous caller, and the U.S. Supreme Court said that an anonymous caller is not enough. However, in this case, it was a 911 call, so this might seem a little bit different because under State versus Galata, which is also upheld in several other states across the country, a 911 call is considered a reliable tip. A 911 call, if you call and you make a false report to the police, it's actually a fourth-degree crime. So in State versus Galata, they actually discussed that, and they said that no citizen in their right mind would call 911 to give a false report about an ongoing crime. And this has been upheld in several other decisions since that date. However, in this case, it wasn't necessarily the fact that it was a 911 call. It was the fact that it was a non-particularized tip. And for us in the street that are actually out there on patrol, we need to remember that whenever we get a tip, even if it's a 911 tip or in-person tips, we want to do as much as we can to confirm it. And that was actually shown pretty well in this next case I want to break down. State versus Keith Hunt. This also was decided within the last couple of weeks. This was May 9th, 2024. This is an interesting case because it was actually decided based purely on body camera and reports. In lieu of testimony, that's all that they used. Kind of similar to what we would see in a summary judgment. So on January 1st, 2022, Patterson police officers responded to a shot spotter. When they got there, they found shell casings and they hear another shooting. They hear shots fired in addition to the original. Officer called over the air, requested to clear the air, and upon seeing the officers, the defendant fled. The defendant filed a motion to suppress, and there's credible evidence that reveals upon seeing the police approach that the defendant not only moves but begins to run. These actions are antithetical to the actions of other males that are observed on scene, and more important, the actions of the female who was literally standing right next to the defendant as the police were rapidly approaching her. In addition to running away, when no other person was engaged in such conduct, the motion judge found that the defendant continuously disobeyed officers' commands to stop, and one officer observed the defendant reaching into his right front pocket. Based on the totality of the circumstances, together with rational inferences from those facts, the motion judge concluded the defendant's investigative detention was reasonable. It's very important to note that it's very well settled that flight alone does not justify a Terry stop by itself. That's discussed very particularly in State versus Dangerfield. Here, the motion judge properly found that the defendant's flight alone was not the sole basis for the investigatory stop. She described the other compelling circumstances, which included police responding to and investigating an active shooter, hearing gunshots within minutes of arriving on scene, and locating live shell casings in the area. Additionally, within proximity to this dangerous scene, officers saw the defendant run and refused to halt in response to the police command. The defendant, unlike the others, fled, and as he ran, an officer observed him reaching into his right front pocket, and another officer observed the bulge in his right front pocket. So here, that search was good, search was upheld. It's very important for us on the street to remember, whenever we get a tip, whenever we're responding to anything involving weapons, it's still important for us to corroborate those tips. We're not going to do that to sacrifice officer safety. However, in the legal world, to make sure that we get all of this evidence admitted, we need to make careful observations and make sure that everything that we're observing is included in our police report and articulated very clearly and very well. So it's something I go over very thoroughly in our report writing class. Again, everybody stay safe, and I'm looking forward to the next roll call with you. Joey Sperlazza signing off.